My lord, in fact, this matter relates to creation of villages.
This is a writ petition.
Writ petition matter. So we filed last year.
Oh, achha, this is a vacation matter. That is
Urgency is involved, my lord. Now, what happened? Page number 81, 41. My lord, the brief background, my lord.
Page 41.
My lord, 41. There was, my lord, the writ petitioner village is having a vast territory, vast land, a huge land.
Just a minute. Yes.
And my lord, there are many localities are there. And localities, to look after the administration of the localities, they used to appoint elders, and they look after. Now, some of the, my lord, the private respondents who are here in 2004, they claim that they became a full-fledged village, and they should be recognized as a headman. That issue came up before the District Council Executive Committee. And District Council Executive Committee 2004 has decided that no, there was no creation process. Because Ilaga 1991 Act is very clear, formation of new villages. There was no such process was there, and you're only a locality. And in order you to become a full-fledged, there should be a process. So this was the decision given by the Executive Committee. May just come to relevant Paragraph 2, my lord.
This is 2004 decision.
2004 decision.
Paragraph 2.
Paragraph 2, page number 42.
Yes.
My lord.
Yes, please.
My lord. The landed property of Snat right tendering is a community land and property, therefore only the commander part of the Snat right tendering through the Executive Committee that has the power to look after and administer the community land. The locality village has no authority over the community land.
What is common darbar, Mr.? Therefore, only the common darbar of the Snat means what? Common darbar means?
Common darbar of the, it is the Executive Committee of the Snat right tendering is a village.
No, we normally, you see, like, why this, or what this common darbar? Does it mean that means this is association of darbar or something like?
In that darbar, my lord, in that darbar, representative of all the localities are also there as a member of the committee of the
common anyway.
It's all the members of that common darbar.
Is it a term used in any act or anything? The common darbar.
It is not used in the act.
Okay, please.
Well, now, may I come to point number 3, well, to save lordship time.
This is
point number 2. I just point out that it is a government property.
It's a finding or what?
Well, it is a finding.
This is a contention.
But it is a finding, my lord. Finding. And my lord, may come to point number 3.
Yes.
Well, until now, there are 8 localities under the Snat right tendering, and if it includes tendering, it will be 9 of them. The Executive Committee shall take sincere responsibility to arrange and mark the boundaries of every locality so as to avoid dispute in future. The Executive Committee shall keep clear rules and conditions with regard to the establishment of localities, especially when promoting the localities to the status of the village. This must be done with the advice of the Pakrao of Right Nongkrem and the CM and his darbar, and when it's ready, it must be placed before the command darbar of the Snat right tendering for approval. And when the conditions are clear, any locality which furnishes such requirements shall be promoted to the status of the village without any objection or procrastination. This was the finding of the Executive Committee. So the claim of those petitioners of the Executive Committee saying that they are the villagers were turned down. Being aggrieved with that, my lord, they filed a writ petition, page number 48. Here, the private respondents, they have filed a writ petition, my lord. Here, 6 writ petitioners are here.
Who are you? You are?
I'm the respondent number 6, respondent number 7 in this.
Like this Executive Committee order was in your favor?
In my favor. In my favor. And against that, the private respondents who are here even now today.
Name of the parties here, isn't it?
Name of the parties are here, my lord. Page number 84. 48.
No, this in that order of the executive.
My lord, name of the parties are not mentioned, reflected, my lord. But being aggrieved, they filed. Page number 84. 48. Now 6 petitioners are there.
Your number?
My lord, My number is, my lord, page number 48, number 7. As a respondent.
Achha, you are responding.
My lord. So 6 petitioners, my lord, the 6 petitioners here, they were claiming that they are the full-fledged village.
Okay.
Now they filed this writ petition.
You were what? You were the leader of the common village.
Yes, my lord. My lord. And the
Common darbar.
My lord. Now the learned single bench, my lord, the para 2 of the judgment, my lord, page number 51.
This was taken up along with another civil revision.
Yeah, another civil revision relating to compensation matter, land acquisition matter.
It was taken up together.
Taken up together revision, and both were dismissed by the learned single bench. May I just come to page number 51, para 2. Then this is the contention of the petitioner. To simplify the case, I shall first deal with the writ petition and then attempt to dispose of the revision petition on the basis of any decision in the writ petition. In the writ petition, the material facts of the case pleaded are that 6 petitioners are stated to be the headmen of the such village respectively, which are all under the Khairem Sameship. And by the passage of time, they become full-fledged villages. So this is the basic claim of the petitioners there. And now I'll come to the contention, the reply given by my party, my lord. Here's a page, is page number 54. Which you can see. Page 54, para 4. May read out my lord. Only the relevant portion, my lord. Is a bulky file, therefore I just try to point out the relevant portion only. The respondents contested the writ petition, but it is the respondent number 7, that is me now, who alone filed affidavit in opposition. The case of the respondent number 7 is that the villages of the petitioners are mere localities within Schneider right entering under the administrative control and management of the respondent number 7. And the sanad granted to the petition number 1 was not a sanad for full-fledged village, but was for mere locality, and that it was the respondent number 7 who has the power to issue the sanad to be confirmed by the respondent number 6. Is the same ship, my lord. It is asserted by the respondent number 7 that the powers of Schneider right tendering has been in existence since the year such. So we denied the claim of the writ petitioners. Now the finding of the learned single bench there, Lordship may kindly come to page number 56, Lordship may kindly come. Para 6, para number 6, my lord, at the bottom, my lord. On careful perusal about the pleadings of the rival parties, I cannot but observe that the only question which falls for consideration is whether the villages of the petitioner, namely such, are full-fledged villages or are mere localities under the administrative
control. The issue is that whether they are independent villages or they fall under you.
My lord.
That is what.
My lord. And therefore the single bench.
What was the decision of the
single bench?
At that point of time, what is the
decision of the learned single bench at that point of time? Upheld the decision given by the exit committee and dismissed the writ petition. That means the claim of the private
committee means the
exit committee of this
upheld your contention.
Yes, upheld my contention. Exit committee of this council upheld my contention, saying that they are only legalities.
Under you.
And yes, and even single bench of the High Court has upheld that contention and dismissed the writ petition filed by the private respondent.
Then what is the problem now?
And now, my lord, they prefer appeal again, page number 65, against that judgment. Page number
against the judgment of the single bench.
My lord, against the learned single bench.
Yes.
Page number 65.
Yes.
And the judgment was pronounced in 2014. Dismissed the writ appeal also. My lord. Writ appeal. Then thereafter, my lord, after a gap, suddenly the private respondent number 4 to 10 here, the same parties, file a petition, separate petition before the executive committee directly.
Reiterating the same issue.
Reiterating the same issue. My lord, kindly see page number 90. Is the petition? Is the
Page
petition?
number 9.
90, my lord.
90.
Now this is filed by respondent private respondent number 4. Similar petition has filed by remaining respondents also. Now the prayer may I take, Lordship, page number 98. The prayer made before the exit committee.
88, yes.
My lord, under the above facts and circumstances stated above, the petitioner humbly prays before the exit committee to issue sanad to the petitioner who has been duly elected in conformation with the United Khasi Chinte Hills Autonomous Citizens Appointment Act, as done in the case of Sansat and Sansat, Shri Sansat and Sansat. Number 2, to prohibit the CM of Khairim to appoint the so-called Sardar of Senate right rendering.
You are reading page?
Well, page number 89.
89.
So sorry, 98. 98.
Yes.
The prayer portion.
Yes. Under the facts and circumstances.
Under the facts and circumstances above, humbly prays before the exit committee to issue sanad to the petitioner who has been elected in conformation with the Census Act 1969 Act, as done in the case and such, to prohibit, number 2, to prohibit the CM of Khairim to appoint the so-called...
where is number 2?
My lord, it's not mentioned number 2, but my lord, I'm just like comma, after comma, 2018 comma, to prohibit the CM of Khairim to appoint the so-called Sardar of Senate right tendering, and to stop the illegal functioning of Senate right tendering. That is, a prayer is against me, which is also against the custom prevailing in the Khairim Sameship, to declare that Maukendring is important. Village is a full-fledged village and not the unit. That is a locality matter of the illegally graded by the Senate right tendering. So 3 prayers are there, my lord. Same issue, seeking for full-fledged declaration of full-fledged villages, stopping me from functioning as the head of the parent village. And number 2 is to restrain the district council also.
Maukendring village was a party in the earlier round of litigation.
Yes, that is me. Me. Now that was the prayer. Now I filed my show cause detail before district council, page number 193.
Page 1?
193.
What is your grievance here?
My grievance now, the district council has a completely reviewed its earlier decision and graded all these.
What is the impugned order?
Impugned order may I come? 206. Start from 206. Impugned order was passed on 30th May. Now may I come to the relevant portion of the order?
Yes.
My lord. Page number 209.
30th May 2023. Okay, we'll issue notice, Mr.
Here, my lordship, we ask for some kind of protection.
This order has been passed in May.
That is true. That is true. That is true. Some delays there because
we'll issue notice and let the interim prayer be considered on the next day. That is better. So we are going like final hearing now. We'll just see whether there is sufficient cause for issuance of a notice. We'll issue.
With regard to my prayer, my lord,
private respondents are also.
Private respondents are there. Let them file a show cause in my miscase for stay, and lordship may decide.
Separate miscase for stay.
Separate. Otherwise, there would be complete confusion.
Okay, hard Mr. Rachel Sangadisha, Learned Senior Counsel, assisted by assisted by sponsor. Issue notice. Returnable in 3 weeks. You are appearing for Mr. Kinta?
Respondent KCDC.
How many?
Respondent number 1, 2, 3.
1 to 3. Learned Senior is appearing for 1 to 3.
Member in charge Ilaka Administration?
Yes, 1 to 3. 1, 2, and 3.
Mr. B.G.K. Quinta, Lord Senior Counsel, appeared for response number 1, 2, and 3. And as such, no formal notice is called for in respect of the said respondents. Stop. However, the petitioner shall take steps for service of notice upon respondent number 4 to
4 to, my lord,
10.
12, my lord.
4 to
4
12.
4 to 12, my lord.
Within 2 days.
Within 2 days.
Okay. Then list after 3 weeks. And then this case also, same issue notice. Where is the miss case? You will follow the same procedure for service of steps here.
But I'll do that.
Same order.
My lord, allow them to file a show cause reply. The lordship may consider for this stay of the impugned order. Confusion is going on there, though I'm still running as head of the village. None of the private respondents have a.
Now, who is administering the villages at present?
But administration is in my hand. All the private respondents don't have a sanat also. But in view of the decision given by district council recently, they may start claiming. Therefore, urgency is there.
Issue notice. The prayer for interim relief will be considered on the returnable date. In the meanwhile, the respondents may file their show cause to the prayer for interim relief. List accordingly. List after 3 weeks. List accordingly. List with the main petition. It is not repaired. It will come automatically. Just say this much. Last time is not it. Listing part is not it. It will come.
Okay.
Item number 3.
May it please your lordship. Your lordship, over here what happened on 21/12/2023.
Bodua, you are back in Shillong.
Yes, your lordship. On 21/12/2023,
Yes.
an order of status quo was passed by the court of the additional DC in Shillong in Miss Case number 1 of 2023, which has been violated, my lord. Which has been violated by the respondent
Is it
number 1.
contempt?
This is civil revision, my lord.
Then how revision lies?
Your lordship, over here we have also we have no other alternative but to approach this honorable court by until
Why no other
27 and also under order 39 rule 2A.
That is before the same court only.
Your lordship, the vacation is going on and taking advantage of
Vacation going on is just.
winter vacation is going on, your lordship. That's
No,
right.
there are provisions for urgent matters.
Yes.
Ask.
I had indicated the same thing to my colleague. That
My
you
lord,
can.
we have
In any case, what order we will revise? Just tell us. You find it out and go approach that court. That doesn't mean that there is a complete ban for a civil court. Cannot take it. No.
my lord, under 227 the court has the power.
227 is a different thing. It's a supervisory power.
Superintendent over subordinate judiciary.
My lord, they kept on violating the order, my lord, of the status quo.
That's okay, but then what we will do in revisional jurisdiction? If you say violation, you file, take steps accordingly.
You say
Even if civil court is not functioning, if you say that there is a contempt, then you come with appropriate application. Tell us what will interfere, what order will pass in this revision. This comes as a civil revision. You are appearing for the respondents.
I'm for they have made us party, KHDC. And in fact, boundary dispute also is
Pending.
going on. But insofar trespass and all those transaction, civil code under section 9 will be having the jurisdiction. They can go to the same code, Your Lordship. That's what I've suggested to my colleague. If an order can flow from this code, that they approach the same code.
No, this code, what? See, this is a revision. In revision of jurisdiction, what order this code will word? This is, there is nothing. There is no impugn order here.
No, my lord. Just they have violated the respondents.
Then you go approve that. Will you do it with the liberty?
Yes, my
Yes,
lord.
the liberty will help them. No?
Mr. K. Borwa, Lord Counsel, appearing for the petitioner, prays for withdrawal of this application, with this withdrawal of this petition, with the liberty to approach the appropriate forum. Prayer allowed. The revision petition stands dismissed on withdrawal with liberty as prayed for.
Highly obliged.
I think we can approach immediately.
Yes, Your Honor.
That he will do. Is his concern.
We are also worried because public project is being constructed in another property.
And guide him which way to do it.
I have already guided much of it.
Obliged, my lord.
Item number 4.
Me, please, Your Lordships.
Yes, Mr. Apol. You are here
This
in
matter.
Shillong.
I'm sorry, my Lords.
You are here in Shillong.
My Lords. My Lords, this matter pertains to my Lords, the Maharam CMC. Now, what has happened here is, my Lords, very peculiar circumstances. In 2016, my Lords, some complaint was filed against me with the Executive Committee of the District
Who are
Council.
you? You are CM.
I'm the same of Maharam.
CM of Maharam.
Same of Maharam. Now, my Lords, in 2016, some complaint is filed against me before the District Council, my Lords. Nothing happens. Matter just lingers on like this. In 1st December 2023, the very same person who had filed a complaint with the Executive Committee District Council in 2016, my Lords, reiterates that same complaint in 2023, December. And, my Lords, on the basis of that, the District Council issues a notice to me. I, my Lords, immediately appear before the District Council and I point out section 5 of the Act, my Lords, which I have reproduced in my writ petition. I'll take your Lordships back to that. Pointing out, my Lords, that the law requires that the District Council cannot hear these issues at the first instance. At the first instance, my Lords, this has to go before the Darbar Hima. That's what the law provides. So, at the first instance, my Lord, you cannot take up this matter. If at all, my Lords, the matter has to go before the Darbar Hima. And besides that, of course, on the merits, I have gone and denied all the allegations against me. Now, between the time frame of, my Lords, 1st of December 2023 and we are standing on the 11th of January 2024, 4 dates have been fixed by the respondents. And, my Lords, they not only do that, by the letter dated, my Lords, 5th of January 2024, they tell me that there are other complaints against you. We will take everything together for the purposes of adjudication of this matter. So, your Lordships will kindly appreciate the hottest haste with which this matter is proceeding. Now, I'll take your Lordships to the, my Lords, the Act. We've reproduced the Act, my Lords. If your Lordships kindly have page.
Now you have appeared before them, isn't it?
I have appeared, my Lords. I pointed out to them that you don't have jurisdiction in the matter.
Now have they decided? You have pointed out before them by which way? Have you
My
filed?
Lords, I filed my objection. I pointed it out to them.
And that has
In
not
response to that, they say, my Lords, there are other complaints against you. We will take all of them together. If your Lordships kindly have a look at page 5, my Lords, section 5 we have reproduced. If your Lordships have.
Yes.
Well, this is section 5 of the, my Lords, Khasi Hills Autonomous District Nomination and Election of CM, Deputy CM and Electors of Hima Maharam Act 2006. Section 5, Term of Office of CM. The CM of Maharam shall be appointed for life from the date of his appointment. However, in the event of any complaint against the CM which prima facie disclose that he has violated any of the terms and conditions of his appointment sanad, or that he has lost the confidence of the majority of his electors, or he has been conducting himself in a manner derogatory to his office, or which may undermine the authority of the council, or he is found to be mentally unfit or incapable to carry out the administration of the Hima due to ill health, old age or habitual drunkenness, the executive committee may after inquiry suspend or remove him from office. Now there is a proviso, my Lords. Provided that any complaint against the same should first be brought to the knowledge of the Darbar Hima. And, my Lords, of course, the second proviso that he cannot be removed without being heard.
No, this is brought before knowledge. It doesn't say that Hima should be
No, but that
adjudicated.
issue has been settled by this court in another judgment, my Lords, which we've annexed also in the writ petition. Because unless the Darbar Hima, my Lords, decides the issue, the executive committee on its own cannot take up this matter. Now, the other interesting fact is, your Lordship.
So it means the power of the executive committee to suspend you is subject to the condition that the same must take
first be
cognizance of the
rooted
complaint.
through the Hima, my Lords.
Is it?
I'm sorry, my Lords.
Is it something like that? Until and the CM takes cognizance of a complaint against you, the executive committee cannot suspend you.
My Lords, at least that's what the law says. Because Lordship,
It's
your
only
Lordship will
about the
kindly
knowledge.
appreciate-
It's only about the knowledge. It's like a copy forwarded to such and such. That would be enough.
My Lords, my humble submission would be no, because this honorable court, my Lords, has already
The
adjudicated
executive
this issue.
committee's function would be subject to the.
My Lords, we are talking
of
about
power
here.
by
Here we are talking about the Darbar Hima, my Lords. We are not talking about any individual same. Now the Darbar Hima is, my Lords, any complaint against any CM from that particular Hima would have to first go to the Darbar Hima. Now, if the Darbar Hima then decides, my Lord, yes, there is a.
Where is the judgment of the?
Well, let's be annexed it. I'll quickly take your Lordships. Your Lordships would find it at page 96 onwards, Annexure 16.
Yes.
Relevant power, my lords, relevant page would be page 99.
Yes.
This, of course, related to the Jingram Sameship, my lords, and your lordships there, 28.4 was that any complaint relating to the functioning and conduct of the Sardar, acting deputy Sardar, shall not be taken up directly with the executive committee without the knowledge of the Darbar Hima.
Which part you are reading?
Well, it's page 99, paragraph 6, after paragraph 6, my lords.
Acha. 28.
Yes.
Part of
That is the provision, my lords, the relevant provision in that particular act.
Yes.
Now, the finding of this court is, my lords, it is no doubt well settled that it is the basic principle of construction of a statute that the same would be read as a whole, then chapter by chapter, section by section, and word by word, recourse to construction or interpretation of statute is necessary when there is ambiguity, obscurity, or inconsistency therein, and not otherwise. An effort should be made to give effect to all parts of the statute, and unless absolutely necessary, no part of thereof shall be rendered superfluous or redundant. True meaning of a provision of law is to be determined on the basis of what it provides by its clear language, with due regard to the scheme of law. Reference may be made to so and so. It is a cardinal interpretation rule of construction that no word should be constructed redundant or surplus in rule of construction in interpreting the provision of a statute. The apex court and so and so, I'll skip this part, held that it is too well known principle of construction that this legislative intention is that every part of a statute should be given effect to. Legislature is deemed not to waste its words or to say anything in vain, and a construction which attributes redundancy to the legislature will not be accepted except for compelling reasons. Well, we can skip this. Held that it is a basic principle of construction of a statute that statutory enactment must ordinarily be construed according to the plain meaning, and no word should be added, altered, or modified unless it is plainly necessary to do so to prevent a provision from being unintelligible, absurd, unreasonable, unworkable, or totally irreconcilable with the rest of the statute. So here, my lords, while the lawmakers first say that executive council has the power, then a proviso is inserted.
What is the finding of these are all proposition of law. What is the finding recorded?
The findings, I'll just take your lordships to the findings. Well, it's paragraph 10 at page 101.
Yes.
The administration of Jingram Sardarship rules is framed by the Executive Committee in exercise of Section 12 of the Act of 2005, and for day-to-day administration of the Sardarship in accordance with the customary practices and also in compliance of the provisions of the said Act of 2005. It is very clear that Section 6 of the Act of 2005, the Executive Committee is the competent authority to take actions such as removal of the Sardar from the office or suspension of a Sardar. The said rules of 2006 only prescribes the procedure to be followed in taking up actions by the Executive Committee under Section 6 of the said Act. Rule 28.4 of the said rules clearly provides that any complaint relating to the functioning and conduct of Sardar, acting Sardar, deputy Sardar shall not be taken up directly by the Executive Committee without the knowledge of the Darbar Hima. Paragraph 12. The court already stated that above that the construction of the statutory rule should be made in such a manner that every part of the rules and regulations should be given effect to, and harmonious interpretation of the provisions of the Act should be made, so that no provision of the Act and rules would be redundant or surplus. In order to make Rule 28.4 of the said rules effective, the Darbar Hima, which is going to consider the said complaint dated so-and-so, failed by the responsible so-and-so, should not be presided by the Sardar or his relative, but one of the members of the Darbar Hima authorized by the District Council for this purpose. It is made clear that if the Darbar Hima requires the hearing of the private respondent so-and-so while considering the complaint dated so-and-so, the private respondent so-and-so, this is on the facts of that matter. But it has to be routed through the Darbar.
There's nothing as such. It says this knowledge. Knowledge means once he is informed about the existence
here in this case, there is no knowledge also. Here in this case, there is no knowledge.
How do you say?
I'll take your lordships to the complaint filed by the respondent at this stage, Millets.
There are private respondents here.
Millets, there are private respondents.
We'll issue notice. Nothing more than that at this stage.
Millets, I would only pray this.
What is the impugned order which you have challenged?
Millets, I'm challenging the impugned proceedings. The entire proceedings as against me, because I'm saying it is without jurisdiction. Millets, may kindly have a look at 1/12/2023, the complaint filed by him.
Where is your prayer, Mr. Paul? Just please come to it.
The notice dated 5/1/2024, Millets, that is the notice issued against me now. where they say after I filed my show cause, my lords, they say that we're going to club all the proceedings as against me. Lordships have it at page 13, my lords. 13 and 14. The notice dated 5/1/2024. All other prior notices dated 6/12, 13/12, 22/12.
Where are those notices? What is the latest notice? 5/1/24.
5/1/2024. Your Lordships would find it at page 93, my lords. The English translation is at page 94, my lords. Lordships have it. Now, with reference to the complaints cited above, the office, after going through the records, has found number of complaints which are not disposed of by the executive committee. These complaints dated 8/2/2021, dated 9/3/2021, dated 17/3/2021 from the so-and-so, and directed you to file your show cause was received on so-and-so, and for reasons it is right to include the said complaints mentioned above along with the complaint dated 8/6/2016.
What happened on 10 January?
Well, it's 10 January, the matter has again been refixed.
10 January, nothing happened.
10 January was yesterday, my lords. 10 January was yesterday.
No, what happened? Yes.
They had filed a petition saying that the matter is being moved,
We are filing this petition.
saying that we have challenged this before the High Court.
No, what is the problem in it?
Well, lords will kindly appreciate. There is a certain proceeding filed against me by a certain Mr. X, my lords. Now,
That is okay, but then what is the problem
while
in
the proceeding is going on, my lords, what you are saying is that we are going to club all other complaints as against you in one complaint and hear it jointly. Whether that is permissible in law, my lords.
What the purpose? This hearing is there. You go on 25/18 hearing.
No, my lords, what has happened is after I file my show cause, I bring to the notice, my lords, that you don't have jurisdiction because of the proviso. Now I am greeted with this reply. It basically, my lords, establishes the mindset of the district council, my lords. Here, there, your lordship will kindly appreciate from 1/12 till 11/1, 4 dates fixed. As a matter of fact, it would be 5 days, my lords. Your lordships have pointed out 10/1, so 5 dates. The hottest haste with which this matter is proceeding, my lord, smacks that something is not right.
So there is element of biasness, what to say?
Against respondent number 4, my lords, we have alleged biasness. And my lords, I have categorically pointed out before them that under section 5 you don't have the power. Now, even if they have to proceed, my lords, they have to first dispose of this objection. This would go at the...
Section 5 doesn't say they do not have the power.
My lords, my humble interpretation of this provision is that they do not have the power to directly adjudicate this issue. It had to be routed through the HIMA. Because your lordships, I'll just take your lordships to the complaint filed now at page 63. Which is the translated copies at page 64. Because if it has been forwarded or my lords brought to the knowledge of the HIMA, it would have been pointed out here. With the reference, if your lordships have it, my lords, page 64.
Yes.
With reference to the subject cited above, we, the Kur Simli Saukpo Maharam, would like to remind you that the Executive Committee of the complaint against Nyanto Simeng, CML so-and-so, 2 dates, 8th June 2016, 21st May 2018. We, the clan, would also like to reiterate to you that the Executive Committee of that the CM has misused the land of our clan and that has been inherited by our fathers. The CM till date has been misusing his power, misusing his power as he took out the compensation money that is rightfully the Simli clan, and he further used his power to issue a patta towards the land which belongs to the Kur Simli Sakwa until there is no more land. As the clan of the Kur so-and-so, we request you and the Executive Committee to take interest in the matter and help us so as to help us to recover ownership of the land which rightfully belongs to us. We hope you will accept this request for the betterment of society. So there is no indication by the respondents, well as the private respondents, that at all it has been forwarded to the HIMA. Complaint of 2016, my lords, revived in 2023.
What is this annexure 8, Mr. Paul?
My lords, this is the notice, my lords.
Okay. From the district.
At page 66 is the translation, my lords. This is the notice given to me on the 6th of December.
Yes, Mr. Ginta, what would you say?
Lordship, at the very outset, I would like to say that who is a chief? A chief, according to the Supreme Court, in T. Kaji case, he is only an administrative officer to carry out the jobs and duties as instructed by the KHDC. Now, the other point is, my colleague was saying that he was appointed as a CM in 1990. And according to the records, the Sanad was sometime in 1991. They have not annexed. Normally, in every writ petition, whenever a chief files a writ petition, he annexes Sanad. It is for some obvious reasons, which I understand. A copy of the Sanad, along with its translated copy, is.
What is that obvious reason? Can you disclose us?
Are they questioning, my lords, that I am the chief?
I'm trying to put it down. I'm trying to say that now the 1991 Sanad speaks about the powers of the executive committee to take action in the event of malactions, maladministration, etc., etc. Now, this law came into being only in 2006. There is no fresh Sanad issued after 2006 that what my colleague is saying that we are bound by that. Agreed. Now, be that as it may, this writ petition is nothing but some sort of to seek a gag order from this honorable court that we are not to do anything insofar this sameship of Maharam is concerned, if it is concerning the writ petitioner himself. That is not permissible, Your Lordship. When we have the power to appoint, we do have the power to suspend also. This General Clauses Act, Article 16, Your Lordship knows that very well. A similar occasion arose sometime in 2017 in the case of same of Malayan.
Now,
Similar
the matter
issue.
has not got to the extent of removing him. Now,
We have not
he's
done.
at
We
the
are
stage
giving
of-
him a chance of
at
being
the stage of show cause.
Yes.
Isn't it? Now, even if he has any problem, or in view of this Section 5,
Yes.
if it is a contention
Yes.
that the executive committee will not have the power,
Yes.
then it can be first raised before the executive committee and be decided.
We have not
Any order
decided.
has been passed on that.
No,
Yes,
we
my
have
lords, what my prayer before your lordships is, let them decide it.
We are yet to decide. We have not made any
I
decision.
have filed
We
my
have not
objection,
taken-
my lords, bringing out to the notice about Section 5. Now, once I do that, instead of deciding Section 5, you say that we're going to club all the complaints.
Where is your objection?
My lords, I'll take your lordships to my objection. Your lordships would find it at page 75.
Yes.
First paragraph, my lords, underlined paragraph. That as per section, this is dated, my lords, 19th of December. With reference to the subject cited above, I, the undersigned, would like to state as follows that as per section 5 of the KGDC, so-and-so, 2006, and more specifically explained in Rule 10.2 of the Maharan Sameship Administration 2 Rules 2009, the complaints are not the electors and they have not followed the procedure by coming to the Dorbar Hima first. As such, the complaint should be dismissed in limine. Now, I'll take your lordships to this Rule 10 as well, my lords. I should, well, let's just bring it to your lordships' kind notice. Rule 10.2.
Where it is?
It is annexed, my lords. I'll just take your lordships. Just bear with me for a second.
Is it page 21?
Starts from page 22,
17.
my lords. Starts from page 22. These are the rules. My lords, at page 30, your lordships would find it. Miscellaneous. Lordships have it, my lords.
Yes.
Well, it's as per custom 10.2, my lords. as per custom, any complaint against the same must be brought to the knowledge of the Darbar by a lingdo or mintri, which shall be discussed in the Darbar convenes for the purpose. A lingdo or mintri cannot directly complain against the CM or the functioning of the Darbar without the knowledge or discussion in the Darbar Hima or Darbar CM. Violation of these provisions by any persons who claim themselves as self-styled lingdo or mintri and misuse official seal of the duly appointed lingdo or mintri is treated as a criminal act, and stern action shall be taken against him, her, as the CM and Darbar may decide.
Not relevant to the present case.
I don't understand how is it not relevant, because it specifies, well, as this would have to be read in conjunction with the proviso to section 5. At this stage, Malaj, as your lordships had pointed out, Malaj, your lordships may issue notice. I am only praying, Malaj, before they proceed with the matter, let them decide on my objection under section 5. If they say, Malaj, that they have the power, let them pass a proper order. I will have recourse to your lordships. I will come back with the order before here, if I am not satisfied with that order.
Even if they decide to proceed, they will have to pass some order. Without passing, they cannot.
Malaj, at this stage, they are not deciding that issue.
We have not decided anything. We have not made our mind also. We are just hearing parties. There is no question for stay of the
Who will
notice.
represent Darbar Hima here?
Same.
In this present case, who will represent Darbar Hima?
Malaj,
Petitioner.
no, it
Now, how-
cannot be the petitioner. It will have to be somebody else.
Say, supposing if Darbar Hima is to be informed, which way?
Well, as Darbar Hima, it has to be brought to the notice of the Darbar Hima by a lingdo
Darbar
or
Hima
a
says,
mintri.
like, now then who will represent now here?
The Darbar Hima is not a party here, Malaj, in these proceedings, because nothing has gone
But
to
then,
them.
if that is the thing that this was done without the knowledge of the Darbar Hima is very, very important party here.
Can I just read the definition of Darbar Hima, Your Lordship?
Yes, please.
Means the Darbar Pulun or General Darbar of Hima Maharam to be convened wherever necessary on the advice
Where
of
is that?
the
Where,
executive
you are reading
Darbar.
from? Reading? Page?
The act, I think. You're reading the act, no?
Reading that. Section 2,
First, can we have the act? Well, Malaj, we had
Clause
requested
D.
the master for the act. This is the 2006 act, Malaj. Page 250, Malaj, I'm sorry, this may not be the same book. Section 2D, Malaj, is Darbar Hima.
page 258, Lordship.
I have the same book, page 258.
This is the Act of 2006.
Malaj.
Appointment succession of the Sardar and admin of
Hima Maharam, Malaj,
Sungat.
2006.
No. There is something, you say 2D is something different here. Do is electors.
Well, this is 2D is the definition of Darbar Hima, Malaj.
Page 258.
258.
258, Malaj.
Okay, so this is,
I think some other act has been flagged.
yes. 258 is approved, yeah. Yes.
Means the Darbar Pulun or the General Darbar of the Hima Maharam to be convened whenever necessary on the advice of the Executive Darbar by the same or any persons acting as such, provided that it shall be convened by the same as chairman at least once a year.
Then?
But there would have to be a complaint before him, my lords. After that, if it is not convened, then they will have the power.
What's the definition of executive Darbar? Again. Means the Darbar of the same, duplice same, with some electors appointed by the Darbar Hima and approved by the executive committee to run the day-to-day administration of the Hima. Such meeting shall be presided over by the same and is in his absence by the deputy same or any other.
It can be taken over by the deputy same, my lords. There is no
You
harm.
cannot put words here. No.
But there has to be a complaint to them, my lords.
Now, who will represent Darbar Hima here?
My lords, in this event, it would be the deputy CM because I will have a conflict of interest.
So make him a party then. We'll see then. If you say that, say so. Otherwise, it will be chaos. It will never be solved. It will remain like that.
That will do, my lords. I quite bow down to what is falling from your lordships, my lords. But my only prayer before your lordships at this stage is that if they have to proceed with the matter, let them decide on my objection under section 5. They may reject it very well.
See, you have filed your showcase. You have raised that question.
My lords.
If they do not decide it and pass some adverse against you, that will become ground for interference.
Much.
My lords, may kindly see the manner in which it is
As
going.
of now, no
your
order has been
lordships-
passed against you.
Your lordships may
this
kindly
court
see the
is-
notice of 5/1/2024.
This
Well-
code is not very much, you see, like very much clear about that part of the knowledge.
Well, it's what I'm submitting.
Darbar Hima.
My lords,
Now that is what confuses.
what I'm submitting before your lordships is, my lords,
You remain CM, you do not convene a darbar.
my lords, if something comes to the Darbar, then I am required to convene a Darbar. That is not the case.
Say supposing, so far as the complaint is concerned, how complaint would be brought?
My lords, the complaint would be brought to the Darbar, not to me. The Darbar Hima, my lords, is an independent authority. That's why, my lords, it is the Darbar that has to be, the complaint has to be brought to. It is not the CM cannot act on his own. And therefore, my lords, if a complaint is brought and I do not do anything, then district council can take action. No, there is a complaint, you have not done anything about it. We are taking up the matter. This is not the case here. And a complaint of 2016, my lords, suddenly revived in 2023. They wake up and they realize, oh, 5 days, we have to finish off everything within 1 month. And then, my lords, the fallacy of the notice of 5/1/2024, your lordships will see, we are proceeding with
For
one
all
matter.
those, definitely we will wait for their reactions. See, those factual accusation, what prompted them to, like behave that way, issue of those notices, that definitely they will have to explain. Definitely this will be standing another footing.
My lords,
But then at this stage,
well, at this stage, I am
when
not,
you are challenging the very authority,
my lords.
that is where you see.
My lords, which is why, my lords, I have molded my prayer before your lordships, my lords, even though we had asked for a stay of the proceedings, I am not asking for a stay of the proceedings. What I am humbly submitting before your lordships is, if at all they have to proceed against me, my lords, let them first pass an order on my objection under section 5.
That's as good as allowing the writ petition, my friend. What? No.
Your lordships will kindly see what is my prayer. Well, I don't understand why is the district council shying away from passing an order under section 5. Very well, reject it.
We'll hear everybody.
They are ably,
When the time comes to pass an order, we'll pass.
they are ably guided.
Why are you so making these preemptive steps? Are you forestalling something?
I am not forestalling anything. I am simply asking you to pass an order. Well, it's what? Why should the why should an authority, well, it's shy away from answering an issue if it has been raised before it?
The matter is yet to be heard by all parties. We'll pass an order, appropriate order.
Well, very well. If they pass an order, my lords, I am simply saying you pass an order.
This writ petition itself is not maintainable. You are too premature.
It's all right. You see, like there is no use if you keep on exchanging yourself. Will not come to any.
It's not going to get anywhere.
My colleague is playing to the gallery.
What should be
I could
done
see
at this stage? That is the main thing. Yes, one way you are correct if you say that, like if you make this observation that if you have to proceed, they will have to first make a finding on section 5. Then that will basically result in disposal of the writ petition. Whether it is allowed or not, that is a different thing, but then that will definitely result. Nothing will remain here.
Lordships, my only humble
But the only thing is that you see, like even if it is for the purpose of determining, if it comes for this court to determine whether at all there is knowledge by the Darbar, how we will determine it?
Well, it's an admitted position that there is nothing before the Darbar. Which is why I took your lordships to the complaint filed. Had there been a dispute on that, my lords, I would have been on our back foot.
That is a statement by you because complaining against you, see, like that is.
Your lordships have run through the complaint. I can take your lordships through all the complaints of 2016, 2018.
Now, here being a petitioner, I don't think you will be able to, represent the Darbar now.
I cannot, my lords. I cannot. There is a conflict of interest.
No, the Darbar is the chief himself, according to. If you
It's presided by the chief, my lords. If in case there is, my lords, a conflict of interest, there will be somebody else.
We have not gone behind our back. Giving notice to the.
Anyway, Mr. Paul will issue notice and you just think about the thing whether you should
pursue.
Implicate this deputy CM as the respondent or not.
He's already.
And in the meanwhile, if they pass any adverse order, you challenge it. What is the problem with it?
Well, I am only apprehensive of the mindset of the district council. Your lordships will say.
That is okay. That will be reflected once they pass this order. Their mindset will be very much clear.
Which is why, my lords, I am only praying for a little observation from your lordships, my lords. If they have to decide the matter, let them decide section 5 also.
Then that will basically virtually dispose of this writ petition.
So it will not dispose of the writ petition because the challenge will remain before your lordships, my lords.
Then with the direction you can dispose of this writ petition. There will be no requirement for basically keeping it pending.
Yes, they can.
Because whatever situation,
I'd be grateful, my lords.
any
Your
order,
lordships will dispose of the matter.
any order passed by the district council will definitely give you a fresh cause of action. You see, you have to challenge it by
A fresh writ petition, my lords.
yes.
What I'm humbly praying before your lordships, my lords, your lordships will then dispose of
What is
this
the
writ
problem in your part in deciding on the issue of Section 5?
No, we are hearing. We have seen
you
that.
can dispose it off by
We
saying
have
that.
seen the show cause. We are yet to make up our mind
question
or
of
say
law.
or to.
We will say that if we see, like, if we have to proceed in the matter, we will first decide on the question of Section 5. And
We
then
know,
we'll
we
proceed.
know what to do, Your Lordship. In fact, they don't have to tell us. We already. We are giving notices. We are not taking any step. We have not.
And there are private respondents also disposing it off without.
My lords, your lordships are not entering into the merits of the controversy.
We will issue notice because this will never be this thing. You will do one thing. You will, if you are to proceed, you will first pass some order on Section 5. Because they have read it specifically.
We'll see to that.
Yes.
Without indicating in the order, Your Lordship.
Managed Senior Counsel, assisted by Mr. Chandra. Issue notice, returnable in 3 weeks. Mr. Bijika Kinta. See, you have named this of respondent number 4 and all by name.
Well, it's because there's an allegation of malafide against him.
So number 4 and
Against 4, my lords, there's an allegation of malafide.
4 and 7. 7 is the private respondent. No. Oh yes.
7 is the private respondent, my lords.
So you have to take steps of notice upon respondent number 7 and
7.
4 and 7.
4 and 7 because there's
Others you will represent, or 4 also you will appear.
in fact,
It's up to you.
I will appear for my name.
We'll take steps, my lords, in addition. No difficulty in that. We'll take steps in addition to copies to my learned senior, my lords. We'll take steps.
Not my office.
Okay. Mr. Sanjay, issue notice, returnable 3 weeks. Mr. Bijika Kinta, non-associate senior counsel, along with Mr. Wanson, appears for the respondent number 1, 2, 3, 5, and 6. As such, no formal notice is called for in respect of the state respondents. Stop. The petitioner shall take steps for service of notice upon respondent number 4 and 7 within 2 days. The primary grievance raised in the writ petition is with regard to the authority of the Executive Committee of the District Council to deal with a complaint against the petitioner without first the same being brought to the knowledge of the Darbar Hima. Stop. The petitioner contends that some complaints have been filed against him without placing the same before the knowledge of the Darbar Hima of
Same of Maharam. Maharam Simship.
Mahram Sinsi. It is the contention of the petitioner that the requirement of section 5 of the Khasi Hills Autonomous District within bracket nomination and election. You will get it in paragraph 2 of the thing. Okay, Act of 2006. What you said? Just lost the sentence. Just tell me. Has not been. It's okay. It is contained by the petitioner that as per the requirement of section 5 of the Act of 2006, the complaint against same must be posed before the Darbar Hima before the same can be taken up by the executive committee or the district council. The Mr. Paul Rana Senior Counsel submits that the petitioner has taken the same plea in his shokos filed before the executive committee, and before the executive committee decides to proceed with the complaint, it is incumbent upon the committee to decide the contention raised by the petitioner. Stop. Give paragraph in view of the submission. At the interim, it is provided that in the event the executive committee of KIG decides to proceed with the complaint filed against the petitioner, it shall first decide on the objection raised in view of section 5 of the Act of 2006 by the petitioner. That will do, I think.
Well, that is my limited prayer. I'm grateful, highly obliged.
Yes, anything? It's nothing. The court says if you decide to proceed with the complaint against him, it will first decide on 225.
Then this writ petition can be disposed of. There's nothing survive. That's exactly what they want. Nothing
Now,
survive.
See, the things remains is that in the meanwhile, if you do not take up the thing, then it will remain pending.
It's subject to them wanting to proceed.
Definitely. There are private responses, that is what the problem is. We do not want to dispose of the matter without hearing them.
The Lordship has already spelled out and indicated this before, today. We understand. We will convey accordingly, and a formal direction of this sort will.
Anyway, you take your things. Just give a full stop. List after 3 weeks.
We know what to do. Much more.
Yes.
Grateful. Highly obliged.
Good day, Your Lordship. Happy New Year.
Thanks.
Greetings from the side of the marvelous for a wonderful.
Yes, Happy New Year to all the members, please.
Hearing item number 7.